Hey, what's up, guys? This is Adam from Rescue Michigan, and we've got a lot to go over in this video. It is Saturday night. We are not live, unfortunately, but we are going to be showing some video tonight, and because my internet connection is my phone, I don't know if having it download and upload at the same time is going to be the right move. But we've got a lot of things to talk about. We're going to be talking about court cases. We're going to be talking about audits. We're going to be talking about our bills and getting them hearings in the House. All things that have had a lot of interesting news in this past week. But first, I want to talk about some good news we have. This is the story in the Detroit News. Yesterday, the Unlock Michigan petition signatures have been approved as ordered by the Michigan Supreme Court. They have demanded the Board of Canvassers certify the petition signatures. The Board of State Canvassers consists of 2 Democrats and 2 Republicans, and both of the Democrats on that board had voted to refuse to certify the signatures. And the reason they gave was absolute BS. They claimed that they needed to have an investigation into the signature collecting methods of Unlock Michigan, despite the fact that the Attorney General had conducted a month-long investigation and concluded that no criminal wrongdoing took place, when it became abundantly clear that the people that were involved in a frame-up of Unlock Michigan were obvious Democrat political operatives, and they didn't want to be charging any of their people with any crimes. So no charges were filed, and the Attorney General said, this was improper, but didn't rise to the level of criminal behavior. And so they concluded their investigation. And yet the Board of State Canvassers refused to certify the petitions. I've been asked about this a lot when I go out talking to groups, because we are pursuing a citizen-initiated law to reform Michigan's election law. And people are asking, well, given that they have stonewalled and roadblocked Unlock Michigan at every turn, why shouldn't the same thing apply to us? And I had predicted at the time that Unlock Michigan was going to win at the court level, as now they have. And before you start thinking, well, the court did the right thing this time, it's not that simple, unfortunately. The reason why I was able to predict that the Supreme Court would rule in favor of Unlock Michigan, and depending on the news story that you read, the Associated Press reported that the decision was unanimous. The Detroit News in this story says in what appeared to be a unanimous ruling, because apparently there was no dissent. So I don't know if it was actually unanimous or if there was just no dissenting ruling. But what I predicted was that the state Supreme Court, even though it is in 4-3 control of Democrat nominees, that they're going to rule in favor of Unlock Michigan. The reason why I said they're going to do that was because most proposals are put forth by Democrat forces. And if the court was to allow the Democrat members in this instance on the Board of State Canvassers, by the way, just to be clear, the Board of State Canvassers is by statute 2 Democrats and 2 Republicans. So they never have a one-party majority on the Board of State Canvassers. It's always 2 and 2. And most ballot proposals are put forth by Democrat forces. Obviously, in 2018, you had the redistricting proposal, the marijuana proposal, and the voter fraud proposal. Excuse me, the voting rights proposal. And that's pretty common. The Regional Transit Authority, tax increases, things that people put on the ballot tend to be put upon by Democrats. And if the state Supreme Court had ruled that it was okay for the Democrats on the Board of State Canvassers to stonewall Unlock Michigan and the 500,000 voter signatures that they collected to put this proposal to the legislature, they'd have a problem in the future with Republicans on the Board of State Canvassers refusing to certify Democrat proposals, because they had literally no legal basis, no factual basis, nothing for their objections. So the court ruled apparently unanimously in favor of Unlock Michigan. And that is critical, because it means that, yes, the citizen-initiated law process does work. So I picked up the Detroit News story coverage of this only because It actually has some of the best comments from some butthurt liberals about this. So we have here, let's see. Well, first I'll quote from Fred Wazolik. I'm guessing the pronunciation for Unlock Michigan, saying we urge the State House and Senate to act promptly to finally strike this awful law from the books forever. Governor Whitmer used this law recklessly to crush businesses, families, and lives. No governor should ever be able to do so again. And of course, that's completely right. When the Emergency Powers of Governor Act was passed in 1945, the legislature could never imagine a governor abusing the power this insanely, literally shutting down the entire state, trampling over the Constitution, trampling over civil liberties. And unfortunately, that's not the reality we live in anymore. And the fact is, Democrats in power will abuse that power in any way, shape, and form. They will destroy anything that isn't nailed down as a civil liberty. So then we have the laughable quote from Keep Michigan Safe, filing a motion for reconsideration. It's not going to go anywhere. Saying it doesn't just allow Unlock Michigan's illegally gathered signatures, not true, to count, but will allow every future ballot proposal campaign to collect signatures illegally. And again, no evidence of that, no evidence whatsoever, but ultimately that's the problem. That's why the state Supreme Court voted in favor of Unlock Michigan. Because if Democrats collect signatures illegally, they don't want that to be subject to a challenge from the Republican members of the Board of State Canvassers. So what the court did was not done because it was the right thing to do. It was done because it was the politically smart thing to do. And Chris Treblecock, is that Treblecock, the attorney for Keep Michigan Safe, is just a partisan hack. And he's just going through the motions. I don't know. Chris can be a female name. He or she just going through the motions, opposing the court ruling against them. So there's that. Then you have the quote from the Board of Canvassers, Julie Matuzak, saying, "We are gatekeepers of election integrity." Sure you are. And election integrity includes petitions. I think we let voters down if we don't exercise the power we have. Well, the problem is you didn't have that power, Julie. You don't have the power to refuse signatures that were collected lawfully and legally by 500,000 Michigan voters. So now we have the allegation here, Keep Michigan Safe, alleged that the petition gatherers had been coached to blatantly lie to convince people to sign petitions and had used other improper tactics. That is complete nonsense. There was at one point an individual who was a contractor for Unlock Michigan, I guess, collecting signatures, who was caught on tape by a Democrat operative telling people to do things that were improper. He himself was a Democrat operative. It was what's called a false flag operation. It was a total frame up. Unlock Michigan did the right thing. They isolated every petition that guy in his operation collected and sent those not to the Secretary of State, but to the Attorney General instead, and said, investigate these people for their attempts to sabotage our petition. Of course, the Attorney General did no such thing, but she did fail to apply any criminal charges to the people that actually were doing the wrong thing. So anyway, all that said, we also have an interesting comment here from Jocelyn Benson, the partisan Attorney General, or Secretary of State, rather, noting that she and her staff refused to certify the signatures until well after the November 3rd, 2020 election. The signatures had been turned in on October 2nd, and it took them until March 26th to verify 500 signatures. Unreal that it would take them that long to if they were verifying 500,000 signatures, I can imagine that taking 5 months, but no, it took them 5 months to verify 500 signatures because they claimed they had to direct all of their staff and resources to ensuring the successful rigging of the election. They didn't say rigging, they said execution of the election. Well, same difference. And then we got a nice quote from Lavora Barnes, obviously a partisan hack. She works for the Michigan Democrat Party. She's their chair. Sadly, the Supreme Court decision has opened the door for illegal conduct to continue on future ballot drives, like the imminent Republican voter suppression effort, which is why this decision is so disappointing, Barnes said. And there it is, folks. What are they afraid of? They are afraid of a citizen-initiated election reform law. That is what they were scared to death of. And the state Supreme Court just said, no, Democrats don't just get to block citizen-initiated legislation over what are lies. So, good news all around. It proves the process does work. So, all to the good. However, as I said at the outset, although it is great that the Supreme Court did the right thing, it was not for the right reasons. It was not because they agreed on the finer points of the law. It was because they understood that politically this would be used against Democrats in the future on their proposals if they were to uphold allowing members of the Board of Canvassers to stonewall a citizen-initiated law just because they didn't agree with it and didn't like it and had a flimsy, lousy, lying pretext to oppose it. And in case you think I'm exaggerating, we're going to go now to the Michigan Court of Appeals. I think I will have to put on my headphones now because I have to listen. We're going to play the recording of the hearing of Lucas Gerhard at the Michigan Court of Appeals this past Wednesday. I warn you, this will make your blood boil when you realize how incredibly either dumb or dishonest a Court of Appeals judge can be when you hear this recording. Now, for anyone that's not familiar with this case, Lucas Gerhard was arrested in August of 2019. He was a 19-year-old college student at the time. He had saved up the summer, all summer long, to buy an AR-15, a lawful, legal rifle, the most popular rifle in America, apparently. And in a private Snapchat group, Lucas shared with his friends a photo of the rifle and said, taking this bad boy up, meaning up to college, which Lucas Gerhard's college, Lake Superior State University, is a firearm-friendly college. They even have an armory where students can check in their weapons. And he said, this ought to make some snowflakes melt, huh? And by snowflakes, I mean snow. If you are a normal, intelligent person, you know exactly what Lucas Gerhard meant by that statement. He meant this would offend liberals. This would offend the easily offended. It would make the snowflakes melt. But somebody who was not even a recipient of that Snapchat message, someone who saw it on her friend's computer, who was herself a political enemy of Lucas Gerhard, an outspoken conservative, and she, a commie punk, called the police, who arrested, well, they didn't arrest him immediately, but the county prosecutor brought charges against Lucas Gerhard for making a terrorist threat, which is a 20-year felony in Michigan. As a result of that, Lucas spent the next 83 days in the county jail, denied bail, before finally being released on an exorbitant $250,000 bail to go home under house arrest, prohibited from going to school, prohibited from going to work, prohibited from using the internet. And he is still, to this day, awaiting trial. However, his case was brought before the Michigan Court of Appeals. His attorneys, great people, Phil Ellison and Matt Grinder. We've had them interviewed on this channel. You can learn more about their case on that episode. I'll put a link in the description. That case was heard before the Court of Appeals this past Wednesday. And we're going to watch the video of that hearing, which you can see it's posted on YouTube. It's on the Michigan Court of Appeals YouTube channel, so you can watch it yourself. But we're going to go through this, and I warn you, you are going to be shocked when you realize how stupid and dishonest a Court of Appeals judge could be. So here we go.
Well, Kelly and Judge Ryan Krause, we welcome you. I'm not going to give the whole speech because I know most of the lawyers won't be able to hear it anyway, and we'll just proceed with the case call, starting with case number 11, 350098, People versus Paul Flulick. I have Mr. Clark endorsed for argument.
Oh, hold on. They're gonna move them right past this.
Proceed, sir.
Since we're judge, those fellow may have been. I believe this is more of a backdoor way of creating the sentence he wanted.
All right. Sorry. Let me
Right,
just
because
skip
that's
over
where my
this. Here we go.
computer is. And also, I just wanted to make sure that the record indicated that I did have a chance to review all of oral argument from yesterday, last night. So,
Okay. So real briefly here, who are we looking at? In the top row, these are the 3 Court of Appeals judges. Judge Michael Kelly, who is believed to be a swing vote. Judge Kathleen Jansen, who is believed to be a conservative. And Judge Amy Krause, who is believed to be a liberal. Bottom left is Phyllis Ellison. Philip Ellison working for Lucas Gerhard. And then in the bottom right, Jillian Sadler working for the deranged lunatic prosecutor. Here we go.
just so both judges know, and I know I've sent emails, but I want to make sure that was somewhere recorded that I did look
Okay.
at everything.
All right, thank you.
Thank you.
All right, Mr. Ellison for appellant.
Yes, good morning, Your Honor.
Good morning.
Philip Ellison appearing on behalf of the appellant on this interlocutory appeal. I guess we jump right into the matter here. I guess before I start though, Judge Keller, are you enjoying your new time with all this extra time you now have, not fighting with me and all of our counsel?
I am.
Oh, there you go. We miss you. There you go. But anyway, anyway, good morning to all 3 of you.
Well, but it's just interesting because you're not representing the University of Michigan in this one, Mr.
So,
Ellison.
Yeah, so it's amazing. Every once in a great while, I veer over to the criminal side on something, and it's rare, and I try not to do it very often. But yet here I am today. So,
Yeah, you caused me quite a stir up on the Supremes on that U of M case, but you can go ahead.
Well, I was going to say, if I'm not rattling cages of judges, I'm not doing my job right. So,
Trying to turn it up.
Oh, well, I don't know about that, but why don't you proceed on this case, sir?
All right, thank you very much. Good morning. The arguments today are essentially that this is a First Amendment protected activity, and I know Judge Krause, we had the benefit of your insight originally when you were part of the panel that dissented from the granting of interlocutory appeal on this. And I guess what I wanted to get across today is that if I can is give you a structure by which to analyze this case, because unfortunately, I think whether you agree guns are good or guns are bad, or, people are supportive. And of course, that's a really hot political topic in today's, political discourse. What we need to do is we need to analyze what this case actually is.
Just to be clear, Mr. Ellison, I don't think this has anything to do with whether guns are good or bad. I think it has to do with what was posted and whether or not that's considered a threat.
Okay, so I don't want to do too much Monday morning quarterbacking here. I am not an attorney. And I will say, every time I have ever been interviewed by the media, especially hostile media, after the interview is over, I always say to myself, oh, I should have said this, I should have said that, maybe I shouldn't have said that. It happens. And when you are in the hot seat, when you are in court representing your client, it's a very different mindset that you are in than someone like me watching the case after the fact and criticizing the lawyer here. So with that caveat, I think this was a small mistake. It shouldn't matter. It really should not matter. But what the attorney was referring to in the beginning was that Judge Krause in the top right, when the Court of Appeals agreed to take up this case on appeal, she was the judge who said, no, I don't want to hear this. And the way that Lucas's attorney just framed it there was, this isn't about whether or not you like guns. And she just said, I know that, dummy. Which you don't want to give the other side the opportunity. You shouldn't be presumptive like that, I think. And again, it might have been better said in another way. But again, it's not going to affect the outcome of the case. But just so you guys understand, that's where things are right now. And we will see in just a moment here. Philip Ellison was actually exactly right to say what this really was about, because that is what Judge Krause's problem is she is hostile to Lucas Gerhard because he is a gun owner. And that's going to come out in a moment here. But as a matter of tactics, it might have been best to have been said differently. So anyway, moving on. By the way, if you guys are seeing the timestamp on this video, we're not going to go for a full hour and 10 minutes. This is only like a 15-minute hearing. So, all right, here we go.
Well, then that's the point I'm getting, because sometimes the things that we see can adjust our viewpoint on what the actual circumstances are with a particular set of facts. So I guess what I would offer today would be this, and if it'll take me about 30 seconds to explain this, would be, first thing you have to decide is whether or not the action that's being sought to be punished by the state is whether it's a statement or if it's an act. And if it's an act, you've got a state, the state's got a lot of leeway into drafting laws and drafting standards by which to conduct themselves. If it's speech, then the issue becomes is whether or not it falls within one of the areas that is not protected by the First Amendment. If it doesn't fall into one of those categories, being true threats, pornography, obscenity, things of that nature, the state has no mechanism and no basis by which to punish that speech. So once you get into that category, the question becomes: is this in fact a true threat?
Can it be both or a combination? In other words, a statement with a photo of a gun with a bayonet on it.
No, a statement is either a threat or it's not. And by the way, Judge, you can't accidentally threaten somebody.
I mean, does that take it out of just a pure statement, or?
Well, that's where I'm getting at about guns, because what happens here is that we're looking at the statement that's made by the SNAP here it's literally is a sentence, or it's two sentences. Taking this bad boy up, this ought to make the snowflakes melt, and I mean snowflakes as in snow, winky face. That's the statement, right? That's the thing that the prosecutor is trying to punish for. Now,
right.
If the act here is we're trying to punish is the possession of a gun, right? Or the actual act itself, then what happens is that we need to separate those two things out. To get to your question though, is I think statements can be evidence of what the action is going to be, but the problem is that the punishment that's being sought to be imposed for the action here is speech and nothing further. So which takes this completely out of the realm of being a true threat. There is nothing here that says Mr. Gerhard was going to shoot liberals or shoot Democrats, as the prosecutor suggests. It's a political statement. I would.
Here's the
All right, get ready to be bombarded with stupidity. Here we go.
The problem, Mr. Ellison, and I think since you did read the order and you understand from where I'm coming, that's true. Speech is protected, but certain speech isn't protected. If someone, as I stated in my dissent on this application, if someone offers to hire someone to murder somebody, even if they don't pay them, even if there's no murder, that's still a crime. And all they did was have speech. And I remember.
That's not what this is. Yes. If I call up a school and say, I'm going to blow up a bus tomorrow, it's no defense to say, I wasn't really going to do that. But that's not what happened. That's not what was said. He did not threaten anybody. That is the question. Was this a threat or was it not a threat? There was no specific threat to anybody. There was no specific threat to any specific person. Nothing whatsoever. This judge just invented a case that's the exact opposite of what we're talking about here. The exact opposite.
The reason that example sticks out to me so strongly is I had to try that exact case in Sault Ste. Marie. And when I was in Sault Ste. Marie, I had jurors say, it's free speech. Anybody can say whatever they want. Here,
it doesn't matter what the jurors said in your completely different case, lady. It matters what Lucas said in this case, which was no threat to anybody whatsoever. And most of all, not in any way, shape, or form threatening to kill anybody at all.
here's the problem. you can't. If you're going to hire somebody to kill somebody, if you're going to make a terrorist threat, you can't do those things. Those are not protected speech. There's no protection for that kind of speech. And in this case, what you have, in my opinion, not speaking for the panel, but in my opinion,
Good.
that what you have here is this was a district court bind over, right? I mean, we're not even to the jury stage yet, right?
Correct.
Yeah. I mean, so to bind it over and let a jury decide certainly seems like a reasonable thing to do under.
No, it doesn't. The facts are not in dispute. It is not a question of fact. There is no question what Lucas said. It is a question of law. Is this a threat or is it not? That is a legal question. This is not a fact question. You're a moron. You should not be on the Court of Appeals. Every single person in Michigan should be embarrassed that you are.
Under the circumstances, I think that snowflakes can be taken in many different ways.
It doesn't matter how it's taken by the listener. It matters what the speaker meant by it. And objectively, no reasonable person interprets this will melt snowflakes to mean I'm going to kill people. This is lunacy. This is lunacy. This judge belongs in a psych ward.
Well, I mean, the defendant admitted he was referring to Democrats. So he admitted that. He put that into context, that he was referring to certain individuals of a political persuasion.
This is the judge that's supposed to be the conservative. Both of them do not belong on any court. They have no reasoning skills. When you apply to law school, you take the LSAT, which is actually a reasoning test. It's not like the bar exam. It's like a test to see, do you know how to think? Do you know how to think? These judges are failing that test right now.
Did he not?
Now, and again, I'm gonna probably criticize some of Phil Ellison, the attorney's responses, but you have to understand, he is digesting the fact that I am talking to at least two, and soon you'll see three, complete, utter, flipping morons. How do I explain this to people who are thinking at a kindergarten level here? And that's not easy to do on the fly.
He did.
So it's not as ambiguous. Snowflakes is not as an ambiguous statement as you would say from just the bare reading of it, because he made an admission.
That's fine, and we're not disputing.
No, it doesn't matter that they're snowflakes. We know what snowflakes are. Snowflakes are liberal Democrats who are easily offended. Yes, we agree what snowflakes are. That's not the question. The question is, were they threatened? Were they threatened by him? And by that, did he make a threat? Not did they perceive a threat. Did he make a threat to them? The answer is no. Yes, this gun will make them melt because, look, I'm a Republican with a gun, as is my constitutional right. And they're going to flip out about it because they're cowardly, wimpy babies.
Part of it. What's key here, though, again, Judge Krause, I think, and I'm glad you brought up that question because it goes back to where I started from. The statement a person makes to solicit for murder is not the crime. It's the act of going to murder, trying to murder the other person.
See, this is a bad analogy. No, he should have said, this is absolutely different. Solicitation to murder demonstrates obvious intent to murder. This does not. They are totally distinguishable.
Person is the wrongful action, not the statement itself.
That's not true.
Well, how can that be? I mean,
I'm not going to get into an argument about it because that's what the case law says. Listen,
you're wrong. You're a complete idiot. Look at how smug she is. Look at this.
I tried solicitation. I tried a solicitation.
I know what a criminal solicitation is when I hear one. No, you don't. That other case probably was a criminal solicitation. This one wasn't. You don't know the difference. But you will destroy a kid's life. I shouldn't say kid. He's 21 years old. You'll destroy an adult's life because you're a smug liberal who thinks you can read minds.
Case. I mean, I'm not going to get into it with you on that.
Well,
I just disagree with you.
Okay, and that's fair. I mean, that's if I could finish my thought though.
No, it wasn't fair.
For the rest of the panel would be is that it's not the statement of here's $500 to kill my wife is the wrong. It's the act of trying to actually cause the death of another to solicit their death. It's the action that the prosecutor, that the state can punish for that. not the speech. You have to separate those two things out, because what's happening here is, and
See, here's the problem. What I was saying earlier, he's discovered that he's talking to three morons, and he's making an intellectual argument about what the difference is between a word and an action. And if you hire someone to kill somebody, it's not the speech of, hey, here's $5,000 to go kill so-and-so. It's the action that is behind it that is what you're going after. But again, he came into this hearing expecting to be talking to intelligent, sentient people, and instead he's talking to these jabbering retards.
Judge Kelly, that goes to your question when you said, can these be combined together? I think in circumstances, speech can be evidence of what the act was going to be or it was to be, but it's the speech itself is protected unless it falls under one of the exemptions that are recognized by the United States Supreme Court.
All I'm saying is that if this young man put on a post of something, hey, if somebody had a whatever kind of gun this was up here, that would really melt these snowflakes. You know, that's a little different than
that's actually exactly what this
photo
is.
Of it. I mean, that to me, that magnifies the idea of a threat under the statute anyway.
Well, but if that's the case, look at the photo then. The photo's not pointing the gun at anyone. It's not threatening to kill anyone. It's not,
Right.
You've seen some photographs of people pointing the gun at somebody. This is a photograph of his police gear and his new firearm in his living room. It's not even in front of a school. It's not in front of any students. Doesn't have a picture of a student. It doesn't have any of the hallmarks or indicia that I would say would constitute as any sort of threat. This is a guy excited about a gun that he purchased.
Right.
And we
Yeah,
have his
all right,
Oakland County
Mr. Ellison.
geared that way. So
Do you have any further argument? I think you answered Judge Kelly's question.
I did. The only other thing that I would point to is I would ask this court, and I would point out the two cases that I think control this case, that aid this case. Ostentowski is a tough case. It doesn't give I think, very good context. I think the two you should focus more heavily on. One is Watts, which is binding on this, would be a binding on this court.
Look at the woman in the top right. Look at that face. This is someone who's thinking, I'm going to nail this kid to the wall. I'm going to destroy his life. Oh, I can't wait to lock him up. I can't wait. I can't wait to teach these Republicans. This woman should be impeached.
If a statement like, I'm going to get my sights within the president if they ever make me carry a rifle is not a threat, or in DRC says, I'm going to F and kill the bee is not a true threat. How in the world melting snowflakes could fit to that category does not meet the standard. And I would argue that the First Amendment applies and protects Mr. Gerhard here from this prosecution from the get-go.
All right, well, you have time for rebuttal. Thank you.
Thank you.
I'm sorry, you said Watts, and what other one did you say?
He might have also mentioned that Michigan law expressly prohibits prosecution for presumptively protected First Amendment speech. And if the judge in the district court or circuit court case it is now, and these three weren't morons, they would know this was presumptively protected First Amendment speech.
Say we should focus on?
DRC,
DRC.
it's cited in the brief. It's the Washington appellate state case. Yes.
Yeah, thank you.
And I guess I'd just say too, I don't know that he was so excited about the gun as he was excited about scaring the hell out of, these snowflakes or whatever.
Oh, we got another mind reader here. We have another mind reader.
I mean, that seemed to be what his post was about.
Well, but that's because it's a political speech. In this context of where we are right now is that there are factions between two political ideologies saying, I don't like the sight of a firearm, and the other person says, I like the sight of a firearm. And I think the difference could be, if you were looking for a distinction, would be is if this gun was an illegal gun in some fashion.
Fair enough. I'm only commenting that you said he was excited about the gun. The post seems to be not so excited about the gun, but the effect the gun is having on.
So what? So what? You have every right to offend people. That's what you should be doing in college. You should be challenging the opposition. You should be making them uncomfortable.
Other people, which the prosecutor is going to say constitutes a threat. But we'll hear
Right,
what
the
she has to
prosecutor's a
say.
lying
Very good.
bitch.
Thank you
All
very
right,
much.
can we hear from the prosecutor, please? Thank you.
Here we go.
Thank you.
Your
I
appearance?
do. Oh, I'm sorry, Jillian Seiler, MP 77564 for the Chippewa County Prosecutor's Office.
All right, thank you.
Thank you. As far as whether or not this was a true threat, obviously the people believe that this was absolutely a true threat. We can't take the words and actions completely out of context with history and what it is that's happening in modern society. I agree with Mr. Ellison on that.
Yes, you have to, actually. And not that you have any evidence of any past history either. That's a filthy goddamn lie, you lying bitch. But even if it wasn't, it wouldn't matter. Lucas Gerhard was arrested and charged over one statement alone. This all melt some snowflakes, eh? That is what your entire case rests on.
That. However, what had been happening just prior to this post was that we had been dealing with more and more school shootings on a regular basis.
In
That
Chippewa
was
County?
something
No, you
that
weren't.
Ms. Bonds
No,
had
you weren't, you
testified
liar.
to was in her mind when she saw this post, and that was part of the reason that it was so concerning to her. That's why she viewed the melt the snowflakes, meaning that the snowflakes, meaning Democrats, were going to be shot
We've
and
had no
killed.
school shootings in
And
Michigan.
that when they melted, like ice melting leaves a puddle of water and the ice is no more, the students would be no more. That's how she had interpreted this particular post.
She's a lunatic. And she's a liar.
I do
She didn't take it that way.
believe very
She knew exactly what
firmly
he
that
said.
this is premature. I think that at this point, the vast majority of the evidence is not in the record. All that we've held so far is a
Why?
preliminary
Why isn't the evidence in the
examination
record?
to show that there's probable cause that a felony was committed and that the defendant committed it. There was evidence that was presented at the preliminary examination. However, the vast majority of the evidence as to the defendant's state of mind has not been entered. All of his Snapchat records were not entered in.
All
Defense is
improper,
arguing
all
yet
improperly
again that
obtained.
this is a photograph of a young man who was very excited about just
And all that
getting his
proves
first
nothing.
firearm. Well, in the hours preceding and following this post, he made extremely
Let me
concerning.
just stop you right there. Is that in the record now?
No, and I'm not going to
No, I don't want you
repeat
to
it.
argue. Don't argue anything, please. That's not in the record because.
Ha!
And I'm not going to get into the statements. That's my point.
You just did.
Okay.
That there is this evidence that exists before and after that would go directly to his state of mind, but you don't have it.
And you can't
And
use it.
at this point, I just believe that it's premature to determine whether or not this was a threat. I would
And
also want to,
what's the standard of review in regards to the burden of proof at a preliminary exam?
it would be an abuse of discretion. Was the decision so violative of fact that it falls outside of the range of principled outcomes? Did the district court find that this was not something that was outside of the range of principled outcomes? And I believe in this case that he did not. And Judge Lambros at the circuit court, when he reviewed it, felt that the district court did not abuse its discretion in reviewing the evidence that it had and finding that there was evidence of a true threat. And in particular, the district court judge had looked at the level of deception that the defendant used in his interview that was admitted at the preliminary examination. So for example, the officers had asked him, do you have any other weapons on you? And he says, no, I don't. Well, then as the interview goes on, it turns out that he has the bayonet in his room.
This is a lie. She should be sanctioned. The Ellison should file for sanctions with the Court of Appeals. She just lied to them. He didn't have a bayonet in his room. He had a plastic replica knife. He had a fake knife that was used against him in evidence. That too was appealable. Unreal. They just lie about him left and right. They lie about him constantly. They shouldn't be allowed to get away with it.
A very large dagger at the end of the firearm. And then as it goes on, it turns out that he also has a pneumatic gun in there in his dorm room, which was not permitted.
Not a weapon.
And then it turned out that
this is not true. This is not true at all.
he also had a police baton, which would have admittedly been permitted.
Yeah,
But every
would have been
time
permitted.
that they asked him, they discovered more and more information. If this had really just been a joke or something excited, I think we would have expected that he would not have had this level of deception consistently throughout the interview. And then finally, I just wanted to point the court to the most recent case on Ostentowski, People v. Vychek, which would be the case number 350341.
Right, we're familiar with that case.
Essentially, in that case where the defendant stated that if he didn't get the money that he was owed, he was going to return to Michigan and take care of it himself, and that he was going to be #Las Vegas. I'm sorry.
Again, I mean, that might not even be a clear threat, but that is something much closer to a clear threat than what Lucas ever said. What Lucas said was no threat whatsoever.
It was going to be #Las Vegas. Had that case only gone to the preliminary examination and not allowed all of the testimony in to explain what hashtag Las Vegas meant, and that it actually referred to a mass shooting from 2 weeks prior, I think that it would have been a grave miscarriage of justice. And I think that this court has been able to look at this and say, in fact, we do need to look at the meaning that words have, and they don't exist in a vacuum. And it's not only what they said that day, but it's what they said.
Understand what she's arguing here. She's arguing that courts can read your mind. She's arguing that whatever you say can be interpreted however the enemy, the left, the court wants to read it. That's what she's saying. It is the total destruction of free speech this woman is advocating for right here.
Surrounding that day, what else to put that in context, and whether or not what he was actually alleging was, or threatening, was a mass shooting. And in that case, the jury found that he did, and this court upheld it. So I would ask that the court consider that, and I don't have any further argument. Thank you.
Any further questions of counsel?
No, thank you.
No.
No? Okay, all right, Mr. Ellison, rebuttal, please.
Yes, 2 points I'd like to make in rebuttal. One is that.
Can you speak up a little bit, Mr. Ellison?
Yeah, here, let me move my mic. Maybe I can move my microphone.
Thanks. Thank
We're
you.
adjusting computers around my office right now, which may be part of driving this here today. So for 2 points I'd like to make in rebuttal. First of all, is that Ms. Sadler makes reference to evidence about how important context is, and yet the prosecutor offered no evidence of context at the bindover whatsoever. They've offered the video. They offered the actual Snapchat, which is an incomplete Snapchat in and of itself, which is troubling in and of itself. But second of all, the only evidence.
That's a good point. Moments after Lucas made that Snapchat, he disclaimed it and said, obviously, I'm not going to do anything with this. I'm just making a joke. The prosecutor lied about that. Lied by omission. She's a liar.
Only evidence that they're supplying, and was referenced by the prosecutor today, was Miss Bonds. I'd like to point out to the court, Miss Bonds was never the intended recipient of that communication. And I think that is
that's a big deal.
Detail that
you can't make a threat to someone that you didn't send your message to.
Gets missed under DRC, and frankly under many other cases that follow the same logic as DRC. Is the court only looks to who was the intended recipient of that message, because sometimes when people get messages which are outside the context, meaning a conversation between friends, they assume, and that's the word Miss Bonds used at the test at the preliminary examination. She assumed it meant things. Because she was not the intended recipient of that, she made wrongful assumptions, and wrongful assumptions mean that she made a wrongful outcome. We don't look at a heckler's veto in the form of First Amendment. We look at what the speech actually meant between those who actually communicated that way. And because the only other witness who was the intended recipient said, I didn't view this as in bad taste, but not as a threat, this contradicts that on a factual basis, the prosecution's basis for their preliminary examination, and what evidence is in the record actually for the context actually cuts completely against the prosecutor as this being any sort of true threat whatsoever. Unless the court has any other questions, I appreciate your time this morning.
All right. Thank you to both counsel for your appearance. Case is submitted. Thank you.
And that's it, guys. On the law and the facts, Lucas Gerhard should have never been charged in the first place. He should have his case dismissed immediately, and he should sue the county for the irreparable damage that they have done to his entire life for this civil liberties violation. But based on the comments and questions from those three judges, I'm not feeling too good about his outcome at the Court of Appeals. So pray for Lucas Gerhard, and please, if at all possible, support him. GoFundMe.com. There's actually two links here. There's one in the address bar at the top, and then there's a shorter one over here. GoFund.me/1FA91702. You can actually also, I'll show you if you look at the address bar, if you put in Justice for Lucas G. For some reason, GoFundMe has been really dumb and required me to create a brand new page. But if you click on that link, it's going to take you right back here. Lucas has already gone through $96,000 in legal expenses. That goal was just something we thought we might reach. We've actually upped it a few times because of the extraordinary, generous contributions of so many people. But he's got a long way to go. He may have another appeal. He may have a trial. And when this is all over, he may have to sue the county to reclaim his life. And that will be another huge amount of money. Probably more than this even. So if at all possible, if you can, please support Lucas Gerhard. He has had his life destroyed by an evil, corrupt prosecutor who knows exactly what she is doing, and by an evil judge who knows exactly what he is doing. He was denied bond for 83 days. He is still to this day prohibited from going to school, from going to work, and going on the internet and defending his cause. And they know exactly why they're doing it. They know he's no harm to anybody. They know he's never threatened anybody. They're doing it because they are sadistic, evil lunatics. So please, if you can, support Lucas Gerhard. All right, folks. Moving on from this topic. Yesterday, Rescue Michigan put out an email. And we've now had 7 bills introduced in the State House on election integrity, which if you've been following Rescue Michigan, you know about these bills already. We've been talking about them in email. We've been talking about them on our website. They are 7 important election integrity bills that so far to this date have not had any kind of bill or hearing or anything in the legislature. And we don't think those are the only things that need to be fixed in Michigan's elections, but they're important elements. And what's happening right now is we are working with other entities to craft a citizen-initiated law. And if we collect the signatures to pass that law the way Unlock Michigan did, the next step is that it goes to the legislature, where they have to pass it. If they don't pass it, it goes to the ballot, and that's a huge amount of more time. And even if we win, it wouldn't take effect until after 2022. So the only way that we can change Michigan's election law before the next election is with a citizen-initiated law. And these are elements of that we want to put in there. So 7 great representatives in the State House introduced those bills. They were referred to the Elections Committee. And in an email we sent this past Monday, we actually said to our members, don't bother the committee chair about getting a hearing. We'll work that out on our own. Because it's basically professional courtesy. We were expecting a hearing. The chairman of that committee, Ann Bolin, she's on our email list. She's been on our Zoom calls, at least one. I met with her a few weeks ago. She knows about it, what issues we're pushing for, what we're advocating for. She knows how important this is. When I went to Lansing this past week, first from her staff, and then one of the sponsors told me after talking to her about getting a hearing that she was pushing back. Now, in Michigan's legislature, they are on summer break. They call it a constituent work period. The rest of us call it a vacation for 2 months. Throughout July and August. We're going to have this citizen-initiated law rolled out probably by the end of this month. We want to have hearings in the legislature. We want to bring our facts out. We want to put it out to show lawmakers how compelling and powerful the evidence is for each of these bills and how important they are. You have Representative Riley's bill, which to my knowledge is is the only bill introduced anywhere to make sure that we have bipartisan representation in poll workers, which is absolutely critical. Poll workers administer the election, literally. The only way they could get away with anything else is by having one side controlling the entire environment, which is what they did in Wayne County and perhaps elsewhere in this past election. We have a bill on poll challenger rights, the rights of poll challengers to video record proceedings. This bill, parts of it have been introduced elsewhere. In this case, it's that bill actually also contains a uniform signature verification standard and how critical it is, but it's especially critical with this bill because the sponsor himself is an eyewitness and a plaintiff to the impeding of poll challengers. And it's absolutely critical that that bill is part of an election reform. We have a bill requiring security features for ballots, which no other bill in Michigan has. Although Tennessee passed a bill very similar just weeks ago, requiring that ballots be watermarked so they can't be easily counterfeited. We have a bill allowing the facts to be determined in quote-unquote unrecountable precincts. Again, probably the only bill of its kind in the country, but other states do things differently than Michigan, and I don't know that other states have the law that we have, which says that if a precinct is out of balance by just one vote, you can't recount it. You can never open that ballot box and look at anything, and it's never going to count ever again. So we have a bill to say you have to consider the facts. Well, you have to find the facts in a public setting so the public can know the facts, and a judge of competent jurisdiction can make a determination as to whether those unrecountable recounted ballots should be applied. We have a bill prohibiting tabulators from connecting to the internet. Unlike a certain other bill that received 2 hearings in the Elections Committee weeks ago, which said that they couldn't be connected to the internet, except when they can be, when they normally were in the last election. We have a bill allowing canvassers to rescind certification if made under duress, which is exactly what happened in Wayne County in November 2020. And it also includes document retention. So we had these 7 bills go in. We need a hearing on them, either this coming Tuesday or the next Tuesday. And that's about it, folks. They may extend session another week into the summer, but if they don't, those are the only chances that we have for these bills to get hearings. So I've worked in the legislature long enough to know when a sponsor is saying, I'm not going to give you a hearing, without saying, I'm not going to give you a hearing. They give you the runaround. They make excuses. And what we heard was, we've got all these other great bills that need to have hearings. So the last video I made on YouTube, check out the link just down below there. We went through each of those bills and showed that most of the bills of the 90 that she claimed were before her committee had already been passed out of the committee. And then most of them weren't related to the election, and most of them weren't time sensitive, and what you were left with was almost nothing. So yesterday we sent out an email blast and encouraged everybody, contact Ann Boland's office, ask her for a hearing. We need to do that. It's important. And thank all of you that did, because that is what is effective in politics, is making your voices heard to the politicians. But this is a teachable moment, because we've also heard some feedback from people who said, oh, this wasn't fair to the chair. And we heard some people saying, well, I don't know if I want to sign your petition because it's better to send a personal letter. So let's get into this. This is important. These are questions of political tactics and how to do what's effective. So here's an email. Here's an email I got yesterday. Let me make this more centered here. From name withheld. I'm told that sending form letters is not as effective as doing your own, using some of the wording that you folks have so graciously provided to us. In the past, these forms are just tossed out. It seems that politicians prefer your own words, and it is a form of spam. So just copy, paste, reword your own way, and send off. Thank you for the feedback. However, this is not correct. In fact, this is one of the big lies spread by politicians. First of all, it's not spam. Spam is sending an unsolicited email. Your legislators have an obligation to receive your messages as long as you are a real person. You're an individual person and you're the lawmaker in charge of the committee that's relevant to every single member in Michigan. You have an obligation to read those emails and answer those emails, or at least read them. That's not spam. Spam is if I buy an email list of 1 million people and just start sending out emails willy-nilly. That's different. And that's not what we've done, by the way. But now to the bigger point here about form letters versus your own personal letter. This is actually one of the myths spreaded by the political class. And they do it because it benefits them for you to believe it. In fact, anytime a politician says to you how the way things go, you have to ask yourself, how does it benefit them if I believe it? Well, if a politician won't accept a form letter, they won't accept a petition that you sign with just one click, you have to write your own letter. Guess what, folks? Most people aren't going to write that letter. They don't have the time. They don't feel they know the issue well enough. They don't feel comfortable enough in their writing, etc. At Rescue Michigan, we have a petition creation tool because it makes it extremely easy for people to contact their lawmakers. And here's the fact. Politicians actually do care about political realities. Some of them are in what we call tough districts. The other side is gunning for them. They want to win majority. They want to knock out the Republicans in the fringe districts. And with redistricting coming up, people don't necessarily know what their district is going to look like next year. It might be a harder road next year. So politicians don't want to have angry voters in any substantial numbers. And even if they're in what we call a safe seat, you know what? They care about keeping majority. They care about their colleagues in the tough seats. Because if they lose majority, they lose everything. Some of them want to be in leadership roles. And being in leadership roles involves helping your colleagues. And that means not having angry voters back home and not having your district become less safe. Politicians actually do care what their voters think. And they live in constant fear of alienating a lot of voters. So when politicians get letters from voters who are concerned about an issue, they're asking themselves 4 questions. What's making them mad? Making them mad enough to vote against me? How many of them are there out there that feel this way? And what's going to take to make them go away? And the third question is by far the most important. How many of them are there? How many angry voters are there on this issue? This is why form letters do work, because you're sending more letters. If a politician receives one beautifully written, handwritten letter from a constituent asking him to do something he does not want to do, well, if he doesn't do it, he's only lost 1 vote. Potentially only 1 vote at all, maybe less. If a politician receives 100 form letters and postcards from constituents on that same issue, well, first of all, that's 100 angry voters. But it's actually even more powerful than just 100 handwritten letters, because a form letter shows the politician there is an organization behind the effort. An organization that might remind voters in the district if the politician does the wrong thing on the issue. A form letter sends the message that these are organized voters in their district that care about this issue. So form letters are effective, folks. And the notion that they're not effective is the politicians trying to get you to not sign those petitions, trying to weaken the organizations advocating for those issues by not having people sign their letters, trying to not hear from the voters on the issues that they don't want them to be upset about. So this is why we sent that email out, because Chairman Bolin has demonstrated, despite the fact that she knows us and she knows these bills and she knows these issues, that she does not want to give us a hearing before summer. So we have 2 options, folks. We either send the letters and we ask for hearings forcefully, or we don't get hearings. And that's how that goes. Here's another email I got. This is from someone that works in Lansing. This doesn't feel very fair, referring to me criticizing Ann Bolin for giving us the runaround. They, meaning Bolin, have moved so many pieces of election integrity legislation. They have at least 19 bills now waiting in the Senate that have moved out of the House. This is epic and something the grassroots should celebrate, don't you think? Well, 2 things to that point. First of all, those 19 bills aren't our bills. And the 19 bills don't diminish from the fact that our bills, which there are nothing like them in the House and Senate right now still need hearings. And it damages us if we don't get hearings on these bills, because it shows that the legislature doesn't care what we think. So we still want to have hearings anyway. But 19 bills in the Senate, at least 19 bills waiting in the Senate. Let's take a look, guys. You'll remember in the video yesterday, we looked at the bills before the House Elections Committee that we are told our bills need to take a back seat too. Now let's look at the bills, the great, wonderful, fantabulous bills that had passed the House and are now in the Senate. So let's see here. Here we go. These are all the bills that have passed out of the House Elections Committee. So here we go. We've got 40 of them. Well, first question is, these are all bills before the Elections and Ethics Committee, but how many of these bills are actually about election integrity? Let's take a look at that question. Tell you what, let me just narrow this column a little bit here. Narrow this column, and now there's a new column that's coming into frame here. Does this have anything to do with election integrity? Well, let's see here. Revised new legislator conflict of interest rules. No. Post online names of clerks who did not get election training. No. Revised lobbyist report due dates. No. Extend the time that election officials have to review and inform election campaign committees of any errors or omissions in the campaign finance disclosure reports they are required to file. I mean, in the most tangential way, but not in terms of addressing vote fraud. Not in terms of that. No. Does not affect election integrity. Make legislator candidate filing fees non-refundable. Make county officer candidate filing fees non-refundable, etc., etc. Eliminate May and August elections. Interesting policy, doesn't affect election integrity. Expand state ethics board's duties. Revise lawmaker conflict of interest restrictions. Impose financial disclosure mandate on legislators, state officers. Why are we even doing these things? Limit lobbying by a former legislator. So much for that First Amendment. Add lobbying restrictions for lawmakers. Revise lobbyist regulation details. Restrict combination lobbyist office holders. Increase penalty for impermissible gift to public officials like Gretchen Whitmer getting a free billionaire's jet to Florida. Affirming states' rights under the United States Constitution to establish election laws. Doesn't do anything. Yeah, you telling Congress, hey guys, knock it off, doesn't do anything. So sorry, no credit for that one. Require 2/3 vote on lame duck session bills. Interesting. We could debate that one. Not election integrity. So let's just go ahead and delete all of these bills that have nothing to do with election integrity. Here we go. Delete, delete, delete. Boy, this list is getting short fast, isn't it? All right, now we're down to 13 bills. So I guess we didn't make the 19, but let's see what else let's see what we have here. Okay, we got 2 bills that do one thing. Revise the procedure for clearing dead, moved, or inactive voters from the rolls. Those are bills for election integrity. Okay, yeah, all right. I'll give you that one. I mean, I'm assuming they're not negative. That's probably a bad assumption, but well, it's probably an okay assumption. Probably right. Make absent ballot interference a felony. All right, tell you what, here's what we'll do. We will give all of these bills the benefit of the doubt if their summaries don't make obvious clear they're not doing something good. So okay, all right, that does something. And here's this, 2 bills do the same thing. There's probably some reason for that. It's a tie bar, so they're amending. Oh, okay, so it looks like one's amending the criminal code, one's amending the election law, so pretty standard stuff. Same thing here. All right, precinct size. Allow precinct consolidation at certain elections. Require clerks maintain a permanent absent voter list. Wait. Require clerks maintain a permanent absent voter list. All right, folks, time to start digging in here. Let's go back to our web browser here and let's start looking up some of these bills. Because some of these I don't even trust to be doing anything. 4134. Let's see what we have here. Increase the maximum number of voters allowed in a precinct from 3,000 to 5,000, and increase that number for certain elections in the interim. Also, require local election clerks to maintain a permanent absent voter list and establish that only these clerk offices are authorized to maintain such a list. I guess I don't really know. I have to think about this for a minute here. Is this important? This says 4,000. That's probably what's introduced. I think they upped it again. Let's see. Nope. As passed by House, 4,000. So they lowered that limit. So the size of a precinct is restricted to 4,000 registered voters. Presumably, the idea is to avoid having to split precincts. So when a precinct is growing, they've got more and more voters. At 3,000, they have to bifurcate into 2 precincts. Now we're saying they can keep going to 4,000. And what else do we have here? Well, I'll tell you what, guys. I don't know that we need to be here all night. But let me ask you, is this in your top 10 list of things Michigan needs to do to fix the elections? To require that permanent absentee lists be maintained by local clerks and allowing precinct consolidation at certain elections? I'm going to tell you what, instead of just yes or no, we'll put hardly. Maybe it does some kind of tiny little thing here or there, but does barely anything. So okay, so what I've done is I've got these 2 columns now. Let me make this clearer here. Hold on. I'm going to shrink these columns down a little bit more. All right, so column E, the small one, does this bill have anything to do with election integrity? You already looked through all those, so that we can delete this column. Does this bill support election integrity? Now we've got yes, charitably. We've got 2 hardlys. Let's see what this one does. Revised initiative petition signature review. Oh wait, no, sorry, that's not election integrity at all. Now, not necessarily an unimportant issue. This is concerning things like Unlock Michigan, things like Rescue Michigan's initiative law, if we have one. Clarifying the time frame to review petitions. So, good policy, but not election integrity. Revised process for removing dead votes from the roll. Okay, we've had some of these already. This is just probably another one, probably part of the same thing. Revised allowable polling place locations. Well, let's take a look. What are we doing here? 4492. Under the bill, a city or township clerk would have to obtain a signed affidavit from the building's owner or manager certifying the owner is not a sponsor of a campaign finance committee. Okay, yeah. I mean, look, passed the House 106-3. So we're going to put hardly. Because if Democrats are voting for election integrity bills, they ain't doing much, folks. Require training for partisan polling place challengers. 4528. Let's see what this one does. This sounds interesting. Mandate that the officially approved polling place challengers who are appointed by political parties and allowed to perform a limited and narrowly defined observer function. I'm not sure I agree with the Mackinac Center's description of this here because it's not all that narrowly defined. Must receive training according to prescribed procedures on polling place process and procedures. Okay, let's look at the bill. This might be one we want to look at here. What are we doing? Establish and require a comprehensive training for each county clerk and for each political party, incorporated organization, and organized committee of interested citizens that seeks to designate election challengers at an election, regarding the processes, procedures, and election day and the powers, rights, and duties of election challengers. Who establishes and required? Let's see. The Secretary of State. Okay. The Secretary of State shall establish and require a training. Any challenger must not serve as a challenger unless they have attended this training. And whoa, what have we here? Each county clerk and the Secretary of State must provide training. Training must include blah, blah, blah. And they must attend and complete. Okay, it must complete. There's a certificate of training. Okay. This is debatable. And I've heard from folks that wanted a bill like this one. The thinking is that Democrats have been bringing in quote unquote challengers off the street who are really nothing more than hired heavies. And from that perspective, I get it. The idea is they don't want poll challengers who are really just thugs who don't know what they're doing. And this is designed to mitigate that. But the problem I have with this bill is, first of all, it's imposing licensure on poll challengers. And it's imposing licensure subject to the training that's developed by the Secretary of State. And there could be some unforeseen consequences in imposing licensing rules on poll challengers, because if the Secretary of State's determination is that the training is not what you think the training should be, well, too bad. You can't be a poll challenger if you don't take this training. So I'll tell you what, I'm going to put this down as debatable. Does debatable have an either? I guess it doesn't. Yeah, well, I'll leave it. It's fine. So does this do any good for election integrity? Maybe, maybe not. Depends on your perspective. Depends on how it actually plays out in practice. Phil Green. This bill we testified about in committee bans the voting machines from connecting to the internet, except during the times that they were connecting to the internet. Right. Well, doesn't do you any good if you're still allowed to connect an external modem at the end of the night, does it? I'm going to just put down, no, this is a smokescreen. This is a fake bill that does not advance election integrity. This bill basically codifies existing procedures, so doesn't do anything. Brad Paquette is the sponsor of one of our 7 bills, so I will go easy on him on this one. It is a bill to allow for absentee voters on their application to ask to automatically receive their absentee ballots for the rest of the year. In my humble opinion, they should have to ask for them every time. In my opinion. And allowing them to ask for all absentee ballots for the entire year on one application does not advance election integrity, because without that, they can still get absentee ballots by requesting them every time. So, no, that does not do anything for election integrity. And what do we have here? Require new signature verification process rules. This one's addressing signature verification. We might have a good bill on our hands here, ladies and gentlemen. Let's take a look. 4845. Require new voter signature okay, hold on. Let's see what this says. Here's the bill. Oh, it's nice and short. Secretary of State shall conduct signature verification training for county, city, and township clerks before the even year primary election and before other elections as the Secretary of State considers advisable. The signature verification training must include, but not be limited to, information on matching and verifying an elector's signature on an election document. The Secretary of State shall promulgate rules to implement the signature verification training required under Section 1 in accordance with and subject to the Administrative Procedures Act. Okay, so this is a weaker version of the Senate's signature verification bill, where they explicitly say your signature verification standard can't just be, we accept every signature presumptively. And actually, this doesn't say anything about an objective signature verification standard. It only says they'll promulgate rules on the training. Well, gosh. The Secretary of State surely had some say in the training of election officials across Michigan to not check signatures at all. This is only talking about training. So does this bill do anything? No. It does nothing. does not have anything about an objective signature verification standard in it. It just says the Secretary of State shall lay out in writing what she was already doing to train poll workers in the existing, non-existent signature verification standards. So let's just delete all of these. Well, there's those no's that go by. Hardleys. Let's get rid of the Hardleys. Revised procedure for clearing dead, moved, or inactive votes from the rolls. Again, is this in your top 10, folks, of things that went wrong in that election? Because I've got some others I'm thinking of. No way for counterfeit ballots to be detected. No signature checks. Poll workers impeded, or poll watchers impeded. Poll challengers impeded. Controlling who worked at the elections. No ID for absentee ballots. Absentee ballots mailed out en masse. Drop boxes. Nothing here about drop boxes, is there? So these 7 bills, which really, I mean, this is a duplicate of, I mean, these are what we call a package. These are multiple bills that do all of one thing. So let's take these 3 down to 1 because they're really only doing one thing. These 2 are only part of the same thing. Revise allowing polling place. Is this in your top 100 problems with the election? Not mine. Here's what we're down to, folks. This is what the House Elections Committee has spent the last 5 months doing for election integrity. Revising the procedure for clearing dead, moved, or inactive voters from the rolls. Making absent voters. Let's look at this Pauline Wenzel bill. We haven't looked at that one yet. 4132. What is this bill doing? Let's see here. What is absent voter? What is absent ballot interference a felony? A person who knowingly submits an absent voter ballot application containing false information or a forged signature is guilty of a felony. Oh, so before it was a misdemeanor. Okay. Oh, well, there's some more stuff. Except as otherwise expressly authorized, a person who knowingly fills out an absent voter application and who without consent submits or causes to be
True international effort to pressure.
Except as otherwise expressly authorized by law, a person who knowingly fills out an absent voter ballot application and who, without consent, submits or causes to be submitted that absent voter ballot application containing or using another person's name and personal information is guilty of a felony. All right. Decent. I'll give her that one. And that's about it, folks. So going back to this, these 19 bills waiting in the Senate that have moved out of the House, you've got at best three small things. I don't think this is epic or something the grassroots should celebrate. I think the grassroots should be insulted. I think they should be insulted that having done so little, we are now being given the brush off by Ann Boleyn. And let me explain to you folks how the grassroots can effectively mobilize for legislative reforms. When the politicians don't want to do something, they have many ways to get you to shut up and go away. First, they ignore you. Then they explain it to you. Oh, I'm sorry, we've got so many other important bills before our committee hearing. We just don't have time for yours. You understand, you're just one of many people out there. And your concerns are only as important as anybody else's are. Okay. If you accept that, you do what the politician wanted. You go away quietly. Well, we did not go away quietly. We sent out an email to 15,000 of our friends saying, hey, call the chair. We want a hearing on these bills. Please, we're not buying your excuses. The next thing the politician will do, because they all do, is get angry. Oh, You can't just deal with us that way. How dare you, sir? How do you bombard our office with these constituents? Well, you didn't give us what we wanted in the first place. What are we supposed to do next? What are we supposed to tell our members? Sorry, folks, we lost. No. So the next thing that they will do is get angry. And perhaps even threaten us. Well, now we're definitely not going to bring your bills up for a hearing because you made us mad. Well, sorry, you left us no choice. And again, if we accept that, then we give the politician what we want. Oh, I'm sorry, we screwed up. We made Ann Boland mad. Well, I guess we just can't have a hearing on our bills now, can we? No, now's the time to double down. Well, it will be if we continue to get pushback. But the other thing a politician will do when public pressure is too much and the other tactics don't work is they will try to buy us off. And in a way, they kind of already have. I mean, this person, and I know she means well. But what would happen, do you think, if I sent an email out to all of our members and said, you know what, the House has moved so many pieces of election
True international effort to pressure.
election integrity legislation. They have 19 bills waiting in the Senate that have moved out of the House. They haven't, but let's suppose I say that. This is epic. It's something the grassroots should celebrate. Hey guys, celebrate, celebrate. We've gotten so many great bills in the Senate through the House. We should celebrate. Well, then I guess Ann Boland's our hero, isn't she? Even though she's blocking our bills from getting a hearing. And instead moving bills that don't really accomplish anything. It could only, in the most charitable definition, even be called election integrity legislation. Look, we tried to make Ann Boland our hero. We presented these bills to her committee. If she had brought them up for a prompt hearing, she could be their champion. She still could be. She still could be. I'm sorry, folks. This was a misunderstanding. You know, I don't know what Adam was saying had happened on the House floor and who he thinks I talked to and who you know, what my staff might have said to him, but there was a misunderstanding. I support these election integrity bills, at least most of them in concept, at least. Let's have a hearing on them. Great. Thank you, Ann Boland. We will be happy to resume singing your praises when we have that hearing. But until then, we must continue to apply pressure. Because in politics, if you can't demonstrate your ability to apply pressure, then why would anybody respect us? So that's where we are now. And on that note, I want to transition to the last thing we want to talk about tonight, which is audits. There's been a lot of talk in the last few weeks about having audits of Michigan elections. Did I have a hold on, let me see if I had a news story about that or something. Well, tell you what, I'll bring this up. The Antrim County lawsuit got dismissed a few weeks ago. And almost immediately, those who were praying for the lawsuit to prevail and deliver an audit are now looking elsewhere. And for whatever reason, they're not looking at the Rescue Michigan proposal for the citizen-initiated law to be fair, I know why. They don't want the rules to be fixed for the next election. I mean, they do want that, but they also want accountability and justice for the last election. And don't get me wrong, I want that too. However, Joe Biden has been sworn in, and there is no constitutional process for undoing an election at this stage. I wish it were different. I wish there was a remedy. And I think we should do everything we can to expose the truth about the past election. However, I think we also have more than enough facts about the last election already. We can prove they used an illegal process to allow signatures that were invalid on absentee ballots. We can prove they inflated the voter rolls. We can prove they impeded poll challengers. We can prove they controlled who was working at the polling places in Wayne County, at least in Detroit. All of which put together add up to more than enough to say the election result is at least in doubt. Will we get to the absolute rock bottom truth? Well, an audit might prove that, and we will see how it goes in Arizona. But you guys have to understand, even if the Arizona audit proves that Arizona should have gone to Trump, it won't be enough. Even if they prove it in Georgia and Wisconsin and Pennsylvania, those alone don't overturn a presidential election. The only body that could possibly offer that remedy is the U.S. Supreme Court. And when they denied cert to Texas for their incredibly well-written, well-drafted, well-argued lawsuit joined by 19 other states, they proved they are not going to do that. So I still think we should have an audit, and by audit, let's clarify what audit means, because the Secretary of State did an audit, but what that audit did is not what perhaps we hoped it would do. It did not take a look at, it was not even what we call forensic audit, which is a term with no legal meaning in Michigan, but we know what that means. It means looking at absentee ballots and did they have a crease on them like any mail-in ballot would? Can we compare the signatures? But there's a push now. There's a push now to call upon the legislature to order an audit the way Arizona did. And I caution you folks. We're all looking at what other states are doing and looking for answers at other states, but you have to understand, other states have a completely different set of rules. And what works in Arizona might not work in Michigan. For example, Arizona has a Republican legislature, House and Senate, and a Republican governor, and a Republican attorney general, incidentally. Michigan has a Democrat governor and a Democrat attorney general. And they are hardcore partisans who will stop any possible effort that they are able to stop. So we're looking right now on my screen at the Michigan Constitution, or sorry, not the Constitution, the election law. And just doing a search for audit, we come upon this chapter. Where is it here? I thought I just saw it. Hold on. Here we go. Election audit procedures. In order to ensure compliance with the provisions of this act, after each election, the Secretary of State may audit election precincts. The SOS shall prescribe the procedures for election audits that include reviewing the documents, ballots, and procedures used during an election as required in Article 4, Section 4 of Article 2 of the State Constitution. The Secretary of State and County Clerks shall conduct election audits, including statewide election audits, as set forth in the prescribed procedures. The Secretary of State shall train and certify county clerks and their staffs for the purpose of conducting election audits of precincts randomly selected by the SOS in their counties. An election audit must include an audit of the results of at least one race in each precinct selected for an audit. A statewide election audit must include an audit of the results of at least one statewide race or statewide ballot question in a precinct selected for an audit. An audit conducted under this section is not a recount and does not change any certified election results. The Secretary of State shall supervise each county clerk in the performance of election audits conducted under this section. Each county clerk who conducts an election audit under this section shall provide the results of the election to the Secretary of State, election audit to the Secretary of State within 20 days after the election audit. That is all there is in Michigan's election law for audits. The Secretary of State shall prescribe the procedures and do whatever she wants. In Arizona, it can be done differently. In Michigan, in 2018, we passed a constitutional amendment to clarify that people have a right to demand an audit. But what the court's going to say is, all that right is what Jocelyn Benson came up with and did, the whitewash audit. And there's nothing in here that says anything different. So Here's an email I got the other day, which I think kind of explains what the audit is all about. How we can get a forensic audit done in Michigan. What's happening? Georgia Bureau of Elections is being asked to oversee the forensic analysis taking place in Georgia, looking at 147,000 mail-in ballots. Interesting stuff. Arizona's forensic audit is not complete yet, but more fraud is suspected to be uncovered. We'll see. What can we do to get Michigan's legislature to investigate our 2020 election? The people in Arizona pressured their Senate. Hey, pressured. What were we just talking about? Pressured their Senate to start the investigation by sending affidavits requesting an audit. And this is what we must do. Hold on. As we just saw, you don't need an affidavit to pressure a lawmaker. They are pressured by numbers of people. Requiring people have affidavits is a stop action. You will get fewer letters. You will get fewer affidavits than you will get electronic letters. So right from the get-go. Where did this notion come from that you have to have a sworn affidavit to ask a lawmaker to do something? No, you don't. Call their office, email their office, and ask them. Tell them you're a constituent. You don't need a signed affidavit to do that. Our Secretary of State says she did all the audits needed to prove Michigan's election was the most perfect election ever. And of course, that was BS. Please help in this effort to pressure Senate Majority Leader Mike Shirkey and other key government officials to carry out a statewide forensic audit. Well, okay. Let's push aside the question about needing affidavits. Let's say we just said, send an email, call their offices, pressure Mike Shirkey and Jason Wentworth to conduct a statewide forensic audit. What are they going to do to force an audit? What can they do? I'm going to come back to that thought. Let's finish this email. Interim Attorney Matt DePerno, that's why I sighed, put together an affidavit like the one Arizona used. With it, we will, according to our own election law, be demanding a forensic audit. We just looked at the election law. There's nothing in this election law about a forensic audit. So download this affidavit here, print the pages, print it off. We have an address. Don't need to send it by certified mail. Don't need to notarize it. Arizona convinced their legislature with only 150 audits. Our guys are a little more stubborn, and so we will probably need a few more. Well, Arizona convinced their legislature with only 150 affidavits. That's not pressure. Michigan has 110 House districts, so you're talking less than 2 affidavits per House district. That wasn't pressure. That was persuasion. Arizona wanted to do this. And remember, folks, the official results in Arizona were much, much closer than they were in Michigan. Much closer. But here's what we're getting at. Our goal is to get 1,000 affidavits delivered. That's less than 10 per House district. A state lawmaker will look at that and say, pressure? There might be 10 votes in play here. Now, of course, there really are more, and they understand that. The letters they get are representative of public opinion that is something larger. But what are they going to do? They can't pass a law. The governor will veto it. They can't order an audit. They don't have any authority to do that. There is, I will give you guys a sliver of hope here. There is one thing they could possibly do. However, I don't think anybody has given them any clue what that thing is. So let me clue you all in. There is an office of Auditor General, and they are a subsidiary of the legislature. However, the Auditor General is a small office, and they are not known to be fast. In fact, they are known to be very, very slow, and their resources are limited. If they were to conduct an audit, they would not be able to hire hundreds of people to run the kind of audit you are seeing in Arizona. what they could potentially do, and again, I'm giving you no promises as to the timeline here, but potentially, they could obtain election documents that ordinary citizens would have to pay tons of money and FOIA fees to obtain, such as scans of the absentee ballot envelopes, maybe even the originals. They could maybe do some things there if directed by the legislature to do. But if those tasks involved any money, it would have to be appropriated by the legislature, and appropriations require the governor's signature. So where does that leave you? What else can the legislature do? A citizen-initiated law. The same thing we've been talking about since the beginning. That is the only thing the legislature can do of meaning that circumvents the governor's signature. Now, should they do this? Let's say, well, first of all, as opposed to the Rescue Michigan proposal, if you had to pick one, what do you want more? An autopsy of the last election or preventing it from happening in the future? My money's on preventing it from happening in the future. But let's say you've got $2 million kicking around and you want to fund your own citizen-initiated audit law. Understand the limitations. It will take 6 months to get signatures. It will take time to get it language written. It will take time to get the signatures approved. It still probably won't get done until the end of next year. So, where are we at, folks? We are right where we started. Our election reform plan. Contact Ann Bolin. We want hearings on meaningful legislation to restore election integrity in Michigan. This is the best shot we have. It might be the only shot we have. So, that's all we have for tonight, folks. We've talked about a lot. We've talked about court cases. We've talked about courts in general. I want to do a follow-up about the Lucas Gerhard stuff because I've been thinking for a long time about what we can do in the meantime to try to help the Court of Appeals do the right thing, which they don't want. Court of Appeals, courts don't like being pressured the way lawmakers do, and lawmakers don't like it to begin with. But that doesn't mean there's nothing that's possible to do at all. But yeah, folks, I hope this has been informative and educational. There's a reason why we do things the way we do, and I think we've broken that down in a lot of major ways tonight. So, hope this has been useful. And again, thanks for all that you do for liberty. This is Adam for Rescue Michigan, signing off. Have a great week.